These are all on page 4. The State of Florida versus Jennifer Kohnert, represented by Mr. Defendant. Case number 26003894 CF10A. Would you like to arraign your client?
Yes.
Would you like to arraign your client?
Oh, yes. At this time, you plead not guilty to the charges.
All right. Demanding discovery, demanding jury trial?
Yes, Your Honor.
Thank you very much. Set this matter for 9/24. Actually, I'm sorry. Set this matter for 8/20. 8/20 for calendar call. Set the matter for 8/31 for trial.
Thank you, Your Honor. There's a bond issue as well. There was a change of charge as to count 1, and then the state added 5 additional counts. Judge, I wanted to address the court on those new counts.
All right.
There's an affidavit filed by the bondsman to transfer the bond from the original charge of aggravated child abuse to child neglect. And then I want to call the court's attention to this, because what I'm requesting is, my client has no prior record. She has 2 children at home, 2 adult children that are waiting for her. There is a pending case with the children, which is now, apparently there's an agreement that's going to be settled.
This is an independency.
Correct. Exactly.
Okay.
And I want to call attention to the court that with no prior record, my client at the magistrate hearing, the public defender at that time asked for a $15,000 bond on the first count. The state of Florida asked for a $50,000 bond. The magistrate on their own required a $100,000 bond. Okay, so there's a very large bond amount in this case already. What I'm asking the court to do is to use your discretion and allow my client to go on a pretrial release for the added counts. So that it does not necessitate her going back into the jail where she's already been and she's already processed through the jail and bonded out originally. By doing that, Judge, there's already a very large bond on this count, on this case. And without getting into the facts of the case, Judge, I just want to let you know, I just received discovery and I've been going through it, but it's my understanding that the minor children have been placed with a officer or attorney who's a relative, and there is an ongoing family dispute between my clients and this relative. And Janine Rice, who's a former prosecutor in the Broward State Attorney's Office, who I believe is guardian ad litem, attorney ad litem, has serious concerns about the bias issue.
Mr. Benowitz, as to the dependency case, as you well know, I have absolutely no jurisdiction over that case, and I will not touch anything that is related to that case. That is being handled by the Supreme Court judge. However, your request as to the counts, and if I understand this correctly, the information that has been filed in this matter.
Yes, Your Honor. If I may be heard on the matter.
Absolutely. This one count of aggravated child abuse, and that particular count is a first-degree felony punishable by up to 30 years in prison. Does it have a midman associated?
It is not, Your Honor.
And count 2 is neglect of child. Counts 3 and 4 contributing to delinquency of life. Is that correct?
That's correct, and 5 and 6, Your Honor.
All right. And so number 5 and 6 are also contributing to delinquency of a minor. Is that correct?
Yes, sir.
Have there been a substantial change in the statutes that the defendants have been charged with?
A substantial change
In the statutes and the charges.
Your Honor, we did file count 1 from the child abuse to aggravated child abuse based on additional information received after the defendants were originally arrested on
He's probably going to plead minors.
And the state is
Probably.
asking for
He
Your Honor
needs
to
to.
increase
It's
the
not
set
private
along to
police
the
at
initial
all.
counts. At the time that this was reviewed by the
This guy's
magistrate
got a
judge,
lot of charges.
the judge thought the facts were so egregious that he increased the bond to $200,000. Obviously recognizing that this may become an aggravated child abuse in the future. Why my office asked originally for a $50,000 bond, I'm not sure. But that is generally we ask for minimum $100,000 on aggravated child abuse. The neglect of a child, I'm asking Your Honor for $20,000. For the contributing of a minor, contributing to the delinquency of a minor, I'm asking Your Honor for $1,000 per count. It should be noted that the state could have sought pretrial detention in this case. We did not file such a motion. And instead, I am asking that Your Honor increase the bond amounts and allow them to be released on pretrial level 1 with a GPS monitor and a mental health evaluation following treatment, and allow them to reside at home until.
Would you please kindly highlight for me?
Judge, do you mind if I chime in? I have the co-defendant on the case.
Nothing at the moment is approval. I will address your client separately. All right? As to the changes in circumstances that address specifically, Ms. Jennifer Renee Kohnert, please enlighten me as to if it's just the same fact pattern and age is added charges, that's a different thing. Is there something that was unknown at the time? Is it something that's new information? Please enlighten me as to.
Thank you.
At the time of the Kohnert's arrest, the state was not in possession of any bail records. The state has since sought at least 10 warrants obtaining additional medical records for the victim child in count 1. And as a result of those medical records, we found that this child hasn't seen a doctor in 6 years. This child was limping for at least 3 months prior to coming into the care of the department. She ended up having to have surgery on both her hips. And prior to that, she was walking to school to and from every single day, regardless of the pain and the obvious limp that she had. Additionally, forensic interviews were done with all the biological children. That's 4 of the 6 had forensic interviews where they confirmed the information that was provided by the victim child as to the restrictions on her bedroom and various other details. And that is why the additional counts for additional victims have been added as well. So there is a medical portion to this that has been uncovered since the original arrest, and there has been evidence of it being, of the other minor children in the household being aware and exposed to the abuse of their sibling.
Absolutely. Give me just 1 second. I just want to make sure that, just so that I have a very clear understanding. There are 3 issues when considering bond. The first, of course, is to assure the presence of the accused at trial. Do you have any consideration that Ms. Kohnert will not appear at trial?
No, Your Honor.
Okay. The second is to protect the community from the risk of harm to persons. Please enlighten me as to whether your concern focuses on that element.
My concern does focus around the family itself. The defendants have been having supervised visits with the biological children.
Is that pursuant to the defendant's report?
Yes, yes, Your Honor. And those are supervised, which by the department. However, there is concern as to whether they're speaking about the case and there's any improper discussions being had with the victim children. Victim children that are biological to Ms. Kohnert are refusing to see the other victim child, count 1, because of the influence from the parents. And so there are issues amongst the siblings not wanting to see the reporting child, the child that reported abuse.
It's so done actually perfectly clear on this. The alleged victim in this case is an adopted sibling of the biological children of Mr. and Mrs. Kohnert. Okay? And the third is assuring the integrity of the judicial process. Do you have any concerns there?
I do, Your Honor. Obviously, the state has filed to a first-degree felony, punishable by 30 years, as Your Honor explained. I saw pretrial detention. We did because I don't believe that she is like this. There is a corresponding dependency case. I am not certain about any resolution to that case. The last I heard, it was proceeding to trial, but we have a file that count under very serious circumstances, malicious punishment, beating of a child, torture of a child. We've also added 5 additional counts that these individuals are now facing, and that has increased their exposure exponentially.
So if I understand this correctly, the state's concern is the potential interaction or lack thereof between an adopted sibling and a biological sibling.
They've grown up together, Your Honor, since she was adopted at 2 months old.
And the other concern is the influence of the defendants over the biological siblings and their impact. That impact they would have on the adopted sibling. Is that correct?
That's correct.
All right, so let's analyze this from a different perspective. You are requesting a bond, all right? Whether they have the financial ability to set a bond as requested, that is an issue. How does that address your concern that there is potential influence or negative influence being exerted by Mr. and Mrs. Kohnert on the biological siblings that would negatively impact the relationship with their sister?
There are any additional funds that are posted, I am sure that the family is going to be concerned about, and any violations to their release, the possibility of losing those additional funds. I think those are considerations that the family must make during the pendency of the case.
All right, Mr. Kavovitz, you have a litany of questions. You're very welcome to address them.
Yes, Judge. You kind of stole my thunder. I think you said it eloquently. I was going to point out that my client is not a threat to the community. She is not a flight risk. She has no prior record and has long-standing ties in the community. The concern that the state keeps bringing up about the concern they have that the child, the alleged victim in this case, is going to be somehow influenced. There's no evidence. They have a concern, and they can have a concern. But it's cyclical logic to keep repeating. The reason they're asking for a bond is because they increased the charges. But when they actually address the force, they have no other additional evidence that they cite to as to why they believe, other than the fact that they filed additional charges and changed the information. So the facts are in fact, going to come out that this child, the parents attempted to have her vaporectomy and were unsuccessful in that endeavor. That the child had a school physical. So it's not as stark an argument as the state is making. The bottom line is, my client is not a flight risk. She is not a danger to the community. They have definite defenses in this case, and there's clear issues concerning the children being taken care of by a member of the Kohnerts Police Department that has a familiar relationship with the family, and they've been at odds prior to this case. That's a concern, that's a problem, and that's why I mentioned Janine Rice, who is an attorney at Lyman in this case, and she has concerns, a third party. But it goes specifically as to the bond judge. There was a huge bond that was paid in this case with a huge premium to a bondsman on count 1. I think that bond is sufficient, I would suggest to the court, that my client could be placed on pretrial release on the other counts. I don't believe there is a necessity for an ankle monitor. They haven't been on an ankle monitor to this point, and they've been perfectly law-abiding and following all the rules as to bond. And I would also just to refute something the prosecutor said, the reason that the biological children don't want to have contact with the alleged victim in this case is because they were threatened to be stabbed by her. So there's actually a valid factual reason why that is, not the inference the state is making that somehow the parents are somehow having influence on their children not to have contact with the child. So that's just not the case, and the evidence will be borne out by that. But when it comes to bond judge, $100,000 bond is a very large bond amount that's already been posted here. We have the affidavit from the bond switching over on count one, the bond amount, and I would just ask for a pre-trial release, level 2, without an ankle monitor. I think my client can abide by all the rules of the court and show up to the court hearing as designated by the
Thank you very much.
Your Honor, I have not heard any testimony as to the defendant's ability to pay, any response, or any testimony from the attorney, Jennifer Renee, referring to. And so, I don't believe there's any evidence that the defendant cannot pay higher terms respond at this point.
Okay. All right. Thank you.
Judge, just to respond to the state's inquiry, I don't have any problem in questioning my client for a moment. If the court would allow me to.
You're welcome to do so. Please raise your right hand, ma'am. Please raise your right hand. Do you solemnly swear or affirm the testimony you provide to the court today will be the truth, the whole truth, and nothing but the truth? Thank you very much, ma'am. All right. Would you kindly state your full name and spell your first and last name for my court report?
Jennifer Kohnert.
Spell your name, please.
First name Jennifer, Jennifer, last name Kohnert, Kohnert.
And your date of birth? Your witness.
Can you tell the court, are you presently married?
I am.
And the name of your husband?
Joel Kohnert.
And what did Mr. Kohnert do for a living?
He was a firefighter paramedic.
And since the onset of this case, what is his employment status?
He came unemployed, well, he was on administrative leave without pay.
Without that?
Without pay.
So the income that you, your family partly relied upon or relied upon is no longer?
We solely relied upon his income. I was a stay-at-home mom.
And that sole income is now gone.
It was not one.
Do you have any assets, any bank accounts or only anything of value?
Just our primary residence.
And where do you live? And do you have any equity in the home?
We have some equity in the home. It's not liquid. We don't have a job to prove that we have a loan off of it. So
Can you tell the court approximately how much you have in any savings and checking accounts at this time?
I don't know. I think we have a lot of it has some consequences. So it's minimal. I know.
So we're not talking about 50 or 100 or $200,000.
Oh no. We sold things within our home just to defend me.
What kind of car you got?
It's currently in the shop.
Awesome.
Ms. Kohnert, are you currently working?
I do have a part-time job that I was able to obtain at Walgreens at 50 cents above the minimum wage.
And how many hours a week are you working?
15, a little more.
Any other jobs on the side?
I am learning some accounting right now and trying to break into that field.
Okay. And are you working for a family member or something in that field?
I am learning from a family member as opposed to
Okay. Are you earning any income from that?
She is providing gas money and extra dollars, so some of it is exchange of services. Yes, about $1,000 every 2 weeks.
Okay. And do you have any GoFundMe or any other donations you're receiving from family, friends, or the church?
GoFundMe now. We have received $100 here and there from people. We've received a, when you put up some drywall, we give you $100. It's odd jobs that my husband and I will receive just to look at and see. I'll let him see his account, but.
Any other donations from family or friends?
Director,
Nothing further.
thank you very much. As to the issues related to cases issued in this matter associated with the additional counts 2 through 6, that being aggravated child, actually count 1, aggravated child abuse, bond will be made as $100,000. And there is an affidavit from the bondsman that the bondsman will remain on bond for that particular amount. As to counts 3 through 6, the additional charges, counts 2 being neglect of a child, counts 3 through 6 being contributing to delinquency of a minor. The court, having considered all of the factors for which bond is to be set, and having considered the relevant factors pursuant to Florida Statute 903046, the circumstances of the offense are allegedly egregious. The penalty upon conviction and the weight of the evidence against the defendant in this matter lays heavy on this court. However, the defendant is presumed innocent until proven guilty at trial. And under the circumstances, the penalty on count 1 is 30 years in prison, count 2, 15 years in prison, and individual counts of 5 years, individual terms of 5 years in prison on counts 3 to 6. As to the defendant's family ties, in this case, I have heard limited information as to that. However, I do understand that there are 4 minor children that are biological children and 1 adopted child who is the alleged victim in this case. The length of residence in the community, extensive. As to employment history, prior from Mr. Kohnert is a firefighter. I understand currently on restricted leave with the Department of Coral Springs. As to financial resources, limited. Mental condition, not a factor. Prior convictions, not a factor. Previous flight to avoid prosecution, no such information provided. Failure to appear at the court proceedings, clearly that is not the case. Mr. Kohnert has been here at every proceeding. Danger to the defendant's releases to imposes to the community. This particular factor, this court does have a concern as to the potential influence that the parents can have on biological children vis-a-vis their relationship with their adopted sibling. However, in order to address those particular concerns, whether I set a bond or pretrial services in this matter, it is going to be for the purpose of setting the restrictions, it is going to ensure that there is compliance with the dependency proceedings. That is the court's orders. And are in effect that will impact the visitations as well as any interaction between the parents as well as the biological children and the adopted child. As to the other factors, this is not a controlled substance issue, and intimidation to the victim falls on my previous analysis. Based on the totality of the circumstances, count 1 remains at $100,000. Counts 2 through 6, pretrial services, level 2 with a GPS monitor, and special conditions, stay away from the victim, no victim contact, all original conditions of bond remain in effect. That is the court's order for counts 3 to 6. Leo, would you kindly prepare that order? Ma'am, please do not leave the courtroom, okay? You are not being taken into custody at this time. However, you will be served by one of the deputies with the case. All right? Thank you very much.
Your Honor, may I just clarify the victim that she's not to have contact with? That's the victim listed in counts 1 and 2, and the biological victims listed in counts 3 through 6.
That is correct.
Permitted, or she's not permitted?
I'm sorry, she's not permitted to have contact with the victims listed in the information, either in person through third parties or through social media. The only modification that can be made to that court order is subject to the dependency court proceedings. Okay?
If I could just suggest that real quick. The 18-year-old, which is one of the listed victims, lives at home in the house with his parents. Would the court consider allowing him to continue residing there at home and just have an order that it should be no discussion?
The concern is the following. Has that been addressed by the dependency court?
I don't know the answer to that.
I would suggest that you speak with your attorney before addressing the court.
So my client informed me that the tenancy court didn't do anything with him to be days away from becoming 18, and to allow this court then to.
Therefore, this court does have jurisdiction over this particular individual. All right, so here's what needs to be done.
He is not a listed victim. The victim, the child they're referring to is not listed as a victim.
Okay,
It's not an issue.
so it's not an issue. The others do not reside in the home, what I understand. My order stands. All right, thank you very much.
Thank you.
Have a very good day. We have Florida versus Joel Kohnert, case number 26003895, CF10A. Mr. DeGogo, sir, if I understand this correctly, there has been a motion filed on behalf of the defendants, and it is the motion for the defendant to be released on his own recognizance, filing number 252-186-696, e-filed 7/10/2026 at 10:58:14 a.m. Are you proceeding on that motion?
Yes, Judge.
All right, Mr. DeGogo, have you had the opportunity to convey?
My argument is relatively.
No. Before we proceed, Mr. DeGogo, have you had the opportunity to speak with Mr. Kohnert to explain to Mr. Kohnert, by having filed this motion, that this court can either remain the same, go below, grant the motion, or deny the motion and take the defendant into custody? Has that been explained to your client?
Judge, I'm having a hard time hearing you, I'm sorry. Could you repeat that?
Yes, sir. All right. So that we're absolutely clear, all right? Have you had the opportunity to highlight to Mr. Kohnert the impact of this particular motion being adjudicated? First and foremost, this now places all of the court's review of what the magistrate did. Now this court can review everything from the beginning. And I can make a determination based on the factors in 903-046. I can go ahead and I can remain the same, hold the same conditions, go downward or go upwards.
Judge, is it possible, my wife broke her leg yesterday, I'm in Minneapolis, is there any possible way I have somebody here and I gotta transport her for like 15 minutes, is there any possible way I can come back and address this issue?
You can, however, there's a capias outstanding.
What was that, Judge?
There's a capias outstanding.
Judge, I was just asking for 15 minutes to come back.
Oh, yes, absolutely, sir. You are more than welcome to. 15 minutes? No problem whatsoever, Mr. DeGogo.
All right, I'll be right back.
Thank you, sir. Mr. DeGogo, sir, very good morning again.
Good morning, Your Honor. Good morning again. I apologize for the morning. I have to deal with. Judge, as far as Your Honor and I, in a separate context, had discussed the relatively recent revisions of Rule 3.134, which deals with defendants not in custody. My only comment is this: as a threshold matter, under the new rule, I'm suggesting to the court, since the information was filed beyond 63 days, that he's actually entitled to an ROR. However, I would refrain from any further comment, but however, I would be willing to accept the same conditions as those imposed upon his wife, which I think would be appropriate in light of the fact that I have been told that the evidence is less or slighter against Mr. Kohnert as opposed to Mrs. Kohnert. And I think Ms. Stein would agree with that. So with that in mind, I would be willing to accept the same conditions as those imposed upon his wife.
If I understand this correctly, there's been an affidavit to remain on bond in case number 26003895 CF10A, or the amount of $100,000 on count 1 to the aggravated child abuse count. Is that correct?
Yes.
And he has additional charges of counts 2 through 6. Is that correct?
Yes, sir.
Yeah. First and foremost, would you like to arraign your client?
Yes. I filed a written plea of not guilty on the case. I'll demand for jury trial. I'm requesting to participate in discovery, and then your plea of not guilty.
Thank you very much. Set 8:20 for calendar call, 8/31/2026 for trial. All right, in this matter, is to count 1 man pages that was issued for Mrs. Kohnert. Thank you very much, Mayor. As to State of Florida versus Joel Kohnert, case number 26003895 CF10A, count 1, $100,000 bond will remain. The report has received an affidavit to remain on bond for that amount. Counts 2, 3, 4, 5, and 6, pretrial services level 2 with a GPS monitor, special condition, no victim contact, stay away order. The defendant may not have any contact with victims either in person, through third parties, or through social media. All original conditions bond remain in effect. Mr. Kohnert, please do not leave the courtroom. You are not being taken into custody at this time. However, you will be served by a deputy with the case. All right? Thank you very much, sir. All right? Mr. Jacobo, is there anything else on behalf of your client?
Nothing else, Your Honor. Thank you so much.
Have a very good day, Mr. Jacobo. Thank you very much. All right?
You too.
All right. Page, please.